President. Mr Assistant President, I lead for the opposition on the Workers' Compensation Legislation Amendment Bill 2018, and let me say at the outset that the opposition does not oppose the legislation. This bill is seeking to address a number of the problems caused by the government's 2012 workers' compensation reforms, and to that degree the provisions of the bill are to be welcomed, but they only start to address some of the issues in fact created by the government itself. Honourable members in this House who were present when this legislation was debated in 2012 will remember that the present government proposed and the Parliament enacted significant changes to the New South Wales Workers' Compensation Act, founded upon the premise that the scheme was in significant financial difficulty. But when you looked at the PricewaterhouseCoopers report that the government based this on, you could see that far less drastic measures were also contemplated and recommended in that report. The scheme, it was said, could essentially trade out of trouble over an extended period of time. There were also less drastic measures than those taken up by the Parliament of the kind that had been embraced in the past when workers' compensation arrangements have needed to be addressed in the past. Governments of both persuasions had apportioned the pain across all the different stakeholders, injured workers being only one of those who have had to make adjustments to ensure the financial viability of the scheme. The key cost driver, or the key cause of the deterioration of the scheme finances when you looked at the report, was in fact the global financial crisis and the much lower returns on investment. And this, of course, is not a problem uniquely being experienced by the New South Wales workers' compensation investments. It was a problem more generally being experienced throughout the developed world. So there were far less drastic measures available to the government than what they took up. And of course, it's a matter of record that, in a financial sense, the reforms enacted by the Parliament yielded financial benefits to the scheme far in excess than what was predicted. And of course, it's also a matter of record that this was paid for essentially in the blood, sweat and tears of the injured workers. And we fought tooth and nail against the reforms which were harsh, unfair and, in our view, unbalanced. But if we fast forward now 6 years later, in the shadow of an election, Mr Assistant President, less than 6 months away, the government, perhaps realising the harsh impact, the harsh and unrelenting impact of their reforms, is seeking to address some of them in this package. This legislation seeks to do a number of things, one of which is to expand the capacity of the Workers' Compensation Commission to deal with disputes between injured workers and the insurer. The bill also addresses the issue of weekly payments to injured workers. This is achieved through a formula known as pre-injury average weekly earnings, and this has been a significant criticism of the scheme since 2012. The main criticism is that it's terribly complicated, and despite the claims made by the government at the time, many workers are in fact being left worse off as a result of this particular change. The reforms in the bill will make weekly payments more transparent and easy to understand and to calculate, and will also allow for the simple inclusion of all earnings in the previous 12 months, including overtime and other additional shifts that are regularly worked. The bill will also allow for indexation of amounts to occur without the need for approval by the Governor and Gazettal. This will allow for immediate indexation and increase at the time prescribed, simply by notification on the relevant website. The bill also addresses a number of issues arising between the compulsory third-party green slip scheme for motor accidents and the workers' compensation scheme when a worker is injured while driving for the purposes of work. Currently, the injured person may receive a damages payment through the CTP scheme and then be required to pay back to the workers' compensation scheme all of the money provided by the workers' compensation scheme during that period. The changes in this bill will clarify and limit those repayments in the future. In matters of this kind, the injured person will only be required to pay back to the Workers' Compensation Scheme the money equivalent to the payments made for lost earnings. The bill also seeks to align the Workers' Compensation Scheme with the National Injury Insurance Scheme for the purposes of commutations and medical expenses for persons in the catastrophic injury category, of which thankfully there are very few. Now, we acknowledge the government has undertaken significant consultation around this bill, and we encourage them for doing that, and we also understand that a number of stakeholders, like the opposition and no doubt other persons in this chamber, are providing a measure of support to the legislation, not because they think the government's on the right track or has a very good record in this area, simply because, as I indicated at the outset, given the catastrophic, harsh and unfair and indeed unwarranted reforms made by this government and Parliament in 2012, this bill is a belated recognition that errors were made and a belated effort to make some correction. And to that degree, a number of stakeholders have lent their support to the measures in this bill because they do in some way wind back those catastrophic and unfair changes. The current Workers' Compensation Scheme is currently around in about $2.4 billion in surplus, and I note, and I think this is taken from the Minister's second reading speech, it makes, if you like, a sort of a trading profit per year of over $500 million.
And has every year since it was...
I acknowledge that interjection by Mr David Shoebridge, which of course just goes to establish the proposition that we outlined, that the reforms proposed by the government and enacted by the Parliament went much further than was reasonably necessary to correct any deterioration in the scheme finances, given that the key driver of those deteriorations was in fact the investment slump caused by the global financial crisis. So to the extent that this bill presents the Parliament an opportunity to correct some wrongs, we do also support those measures. However, we will also be proposing additional amendments which have been lodged with the clerks to make additional improvements, and we would invite honourable members in this place, including the government, to also support these measures. Our proposed additional measures would address the 5-year cut-off for injured workers, section 39 of the existing Act. We think that simply has to go. The arbitrary 260-week or 5-year cut-off for injured workers is working a terrible injustice. There has already been a number of self-harm and suicide events related to this element of the Act. Having such an arbitrary point in time in which an injured worker is cut off doesn't suddenly make them healthy or well or able to seek alternative employment.
It just makes them poor.
Well, I acknowledge that interjection. It not only makes them poor, but in many cases it punishes them, pushes them beyond the edge of not just financial viability, but pushes them to the brink, and in many cases over the brink, of mental collapse. It's really driving a terrible injustice, and that is within our capacity to address it, and we should do so. We also want to remove the option for an employer to sack an injured worker after they have been off, after more than 6 months. This was a measure originally put in place to protect injured workers. You couldn't sack an injured worker for 6 months after the injury, but now it seems to become a, if you like, a milestone for employers wanting to, well, I acknowledge that interjection. It's the point at which some employers are seeking to take advantage of the legislation and opt out of their social responsibilities to those who have been injured while in their employ by saying, well, look, you know, this is not going to be our problem anymore. We're going to offload these people like there's some commodity that's no longer needed. We think this is unfair, and again, it's cruel and it should be addressed, and we will propose an amendment which does that. Section 32 capital A of the current Act defines suitable employment. Now this is an Orwellian provision if ever there was one, because the legislation proposed by the government said, well, suitable employment doesn't actually have to be employment that really exists anywhere, or which this worker, or indeed any worker, could realistically hope to obtain. It's just simply employment that might exist somewhere, in theory. And against this benchmark, injured workers are being held and then turfed off the scheme. We fought this measure tooth and nail when it came before the Parliament in 2012. At every opportunity we have urged the government and this Parliament to revisit this most unfair provision, and we will be proposing an amendment. Our amendment would amend the provision to make it so that A, the job would actually have to exist somewhere, B, that the job is reasonably situated and was within realistic reach of the injured worker, and C, that the job is actually available in the employment market. There is no requirement for these conditions to be met at present, and they should be. This provision should be redefined to have those elements. We also seek to, through our amendments, to restore journey claims that most often affect workers with disabilities through trips and falls when using public transport, but also it also just affects all workers. It's one of these, if you like, ideological things. When the Workers' Compensation Scheme was created, the Labor Party took the view that travelling to and from work was part and parcel of going to work.
It's hard to do work without it.
Well, it is indeed hard to do work, and it's also a social justice measure to ensure that workers are covered. And of course, famously, the Greiner government took it out, and the Carr Labor government put it back in, and this government took it out, and we're going to put it back in. We're going to put it back in because it is fair and reasonable and necessary to avoid injustice. So we will do that. We'll also insert specific words so that the ability of the Workers' Compensation Commission to review and determine a work capacity decision that might be different to that of the insurer is an explicit ability conferred upon the Commission. In the government's bill, they are asserting that the Commission will have the power because it's no longer explicitly denied. Well, we don't think that's good enough. We think we want to make it a positive to avoid further disputes about whether or not the Workers' Compensation Commission will in fact have this power. The power should be explicit because we are dealing here not with, for example, a court where you can imply certain necessary or inherent functions. This is a statutory body that only has the functions provided by the Parliament. And frankly, if injured workers and their claims are to be tied up in knots over whether or not the Commission does or doesn't have certain power. Oh, sorry to be keeping you up, Don. Nice of you to join us. The fact is that this power should be made clear and explicit. Finally, as I outlined, the changes to the weekly payments to injured workers in the government bill, the pre-injury average weekly earnings, are changes, and these changes should not be limited only to new injured workers entering the scheme. Our view is that it should be applied to existing injured workers because it is a better, more transparent and more genuinely reflective measure dealing with pre-injury earnings. And so we will seek to visit this new definition on all the injured workers being provided support in this scheme. Overall, Mr Assistant President, the government bill should be supported, but it is far short of where it should and ought to go. As a responsible opposition, as the alternative government of this state, we'll propose constructive measures that take the scheme further towards the goal that we think it should have. But even these measures do not right all of the injustices created by the 2012 reforms. There will have to be more said about these things and more done about them after the next election. Mr Assistant President, with those words, we would urge all honourable members to give genuine and open consideration to our amendments that are put forward constructively in good faith, and we would urge members of the House to support them.
Mr Assistant President.